So, whoops.
Recording in progress.
All righty. Hello, everybody. Of course, at the last minute, I chose to switch input devices because the computer that I was working on the other presentation this morning was having internet challenges, and so I'm running 5G, so I can't get any faster, I don't think. Because sometimes it's 6, but anyway, so we were having some problems with that. So thank you all for being here. First, let me say we are being recorded, so you definitely being listened to. Actually, you can't. They can't hear you. They can hear me. But we'll talk about that. So anyway, we are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there is my telephone number, and there is my email address. And so far that works pretty good. If you need to get a hold of me, email is usually the best way to do it. Okay, so I'm not seeing that I'm getting any volume out of this. That's kind of scary. So let me reset for a second here, see what we got. And I should have known better than to do this, but I didn't. No, that should work. Okay, all right, let's try it again. Where am I? I don't know. So we will go back to full screen. There it is. And then I'm just assuming that you can hear me just fine. So there I am, and there is my full screen. Okay, so again, welcome and thank you for being here. And thank you for riding through a little bit of, oh, there we go. Now the microphone's working great. Okay, all right. So that being said, I do have a broker's license in several states. I've been in real estate since 1979, so I just put in 40 plus years because it just seems to keep growing on me, so to speak. Got lots of credentials that are going to make me qualified to talk about the subject matter today. And since we're going to be talking about disclosures, I'm going to tell you that if I'm going to get hauled into court for something, it's going to be for failure to disclose something. And so we're going to talk about some of the key ingredients of that. And hopefully I'm going to keep you out of harm's way. Because listen, I like going to court. There's a lot of money in that for me. But I can tell you that for you and I as an industry, it's not good for us. And as you can tell by the recent court holding in the Midwest, sometimes it just doesn't go the way you want it to go, and sometimes it doesn't go the way you think it's going to go, and so we have to be prepared for that. So there's no money in going to court unless you're being paid to be there. So that being said, we're going to try to keep you out of court today. Today's a good day. We're going to have a good day here. So we're going to be talking about things that appear to be legal. I'm not a practicing attorney, and I want to make that really clear. I have no interest whatsoever. My last semester of law school, I decided that there was no way I was going to practice. Frankly, I'm having way too much fun. I got my license halfway through my career so far. I mean, it's just kind of worked out that way. I got my law degree rather, and And that happened back in the 90s. And I just knew I was going to keep doing real estate. So hopefully you're having as much fun as I am. And if you aren't, please let me know. I want to help you have fun at this. This is a good business, but we have to know how to take care of people. And so again, disclosure is going to be a hot topic for us. So my trial work, and I'm not a practicing attorney, but I do a lot of trial work and testifying as an expert witness. So I am considered a court certified expert witness. And remember, the Department of Real Estate says you may not call yourself an expert unless it's in a title. And so a court certified expert witness, I can call myself an expert, a certified distressed property expert, a CDPE, you can call yourself that expert in the title. You just can't call yourself an expert otherwise. I mean, you never want to run an ad that says the neighborhood expert. They will have a ball with you on that. That's definitely not the way to go. So standard of care is my specialty. Did the licensee do what they were supposed to do? Could they have done it differently? Whatever. My work is mostly in defense of real estate brokerages. Agents' duties of inspection and disclosure, and then finally market conditions in San Diego County. And so those are all relevant for us. And so our conversation today is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. You need to be talking with them. And I can tell you, I had a conversation with a broker today about a problem child agent. And my comment was, it's the ones I hear from that I don't worry about. It's the ones that I never hear from. Those are the ones I worry about. So you need to be talking to your broker. You need to tell your broker what's going on. Keep them up to speed on things. That's why you hired the broker. You hired the broker. They didn't hire you. You hired them to help you, to watch over you, to give you advice, do things like that. Okay. So our webinars are intended to be interactive. That means please ask questions as we go along. Please utilize the Q&A button to ask questions or offer input. And I do look forward to hearing from you, because it helps me to shape the direction we take in these. And as I said earlier, if I'm going to get hauled into court, it's going to be an issue over failure to disclose. And so we need to be talking about those things. So please ask questions. Don't be shy. If you do them in the Q&A button, that would be the best way to do it. Nobody else can see those questions. I'm the only one that can see them. So I will repeat the salient parts of the question. I won't call you out by name, I mean, anything like that, but I respect your privacy. But in the beginning, when we were doing this way before COVID, we had the ability to go what we refer to as hot mic. But then as time went on, we realized that when people would mute themselves, the program would unmute them at the worst possible time. And so we kind of got away from that. But we're going to, at least I am going to start doing podcasts, and those podcasts will be interactive, and they will probably be hot mic. So only because I'm going to be using a different program. I don't use the Zoom, I call it Doom, but I don't use the Zoom program for some of the things that I do. And frankly, on that note, the Department of Real Estate, I did a 4-hour webinar for them on the new RPA. And they told me they don't use Zoom because it's not secure. The risk is not for you, the listener. The risk is for me, the presenter. But they use Microsoft Teams. And so I have a Teams account. I have a Google Meet account. I suspect we'll be doing the podcast with the YouTube Premium account. And so be aware of that. Those are going to be really good, I believe. And probably our flagship will be the buyer representation agreement. We'll talk about that in a little bit, but that's just taking the country by storm right now. I happen to be a broker in Virginia, and in Virginia, they've said, we don't worry about it. We legislated buyer representation agreements July 1st of last year. So they really don't worry about it. And in a conversation I had, not a conversation, I'm sorry, I was in a discussion with the attorney, the head attorney at CAR. They said, if we've got to legislate this, we can probably do it fairly quickly. I think that's the way it's going to go, because we were on the teeter of that anyway. And I think that's what's going to happen in California. And so get good at that, because, it's not what people think it is. It's onerous for some of us, but, for most of us, like I said, I like going to court. You don't want to go there. It's a bad place. There's clearly no money in it. Okay. All right. So today is the 9th of November, and we're going to be talking about, we talked this morning about the top 10 risk avoidance techniques, formerly known as lawsuit avoidance. They just kind of wanted to tone it down a little bit, but, so we're going to call it risk avoidance or risk management. And then this afternoon, we're going to talk about the top 6 disclosures. So that's our agenda for today. We're going to talk about disclosures, and I'm going to bring the hot ones up, and we'll talk about those. I personally think it should be renamed the top 8 disclosures, but some of them apply, all the time. Some of them don't. So we'll talk about that too. So on Tuesday, we will be doing residential property management forms, and then in the afternoon, we're going to do SDAR has it listed as to how to create zip forms, but that wouldn't really, it's really how to create amazing zip forms templates, right? But that's what we're going to do. I'm going to do a whole class on that. I think that'll be fun too, because I've got some things to show you that I really have never shown anybody before, and I'm showing more and more people the ability to email directly into the transaction by simply copying an email address that is created for you up in the Zip Forms program automatically, and then you just email it into the transaction. You don't have to, at the end of the transaction, you don't have to do PDFs of all the emails and stuff like that. So we'll talk about that on Tuesday. Okay, so Tuesday afternoon. So member benefits, San Diego Association of Realtors, thank you for joining us for our discussion, the top 6 disclosures. And so I say that that's also known as, AKA, also known as, I really want to be sure that these are in my file. And so again, Albert Einstein coined the term, if you are doing things the way you've always done them and you're expecting a different result, that is the definition of insanity. So heads up here, we'll talk about some of these things. So why even disclose anything? And so California is prior to the Lynch case, prior to the Easton case, California was a buyer beware, caveat emptor. Emptor is Latin for buyer, so let buyer beware. And then as time went on with those landmark cases that came about, the courts felt that the seller should be disclosing things that they knew or should have known, and the agent should be paying attention to what they're selling. And there really was no liability prior to that, really, of any extent. But the Easton case, and we'll talk about the Easton case in a minute, about why it spawned all of this. It was essentially the genesis of the TDS, the genesis of California Civil Code 2079, which is the civil code that you and I are responsible to. Okay, so again, California, it went from caveat emptor to caveat vendor, which is let the seller beware. As a broker in Virginia, I can tell you that it is the opposite. In Virginia, they don't disclose anything. In fact, agents run around thinking that they should not say anything about anything, or else they could get in trouble. And so it's just kind of the opposite of what we have in California. It not necessarily better, okay? And so again, I did a transaction with a new licensee in California who had been a licensee for 20 years in Virginia, and it was her first transaction in California. And she was shocked. She said, I just cannot believe the difference between the 2 states. In California, and I'm sending her all these disclosures, and she's like, wow, that's a lot of stuff. And in Virginia, of course, they don't have any of that. The state prepares a 1-page disclosure for you. But essentially, the attempt is really to move the realtor aside and make them more of a facilitator. And again, Virginia, like California, is a title theory state, so title insurance versus having an attorney draft an opinion of title in the transaction. So again, those are my differences. Why even disclose anything? So let's talk about the Easton case. And so Easton's kind of a cool case, and so I like talking about it. Most people don't. Most people are afraid of it, right? But the Easton case, and I've done some highlights on here. And again, like everything else that I do, I am more than happy to send you this so that you would have it in your file. So this and everything else I'm going to show you today, and I have them all numbered, so I make sure I do them in the right order. So the Easton case, the buyer's name was Easton. They were buying a property, and again, this was they were represented by a broker, and and the seller's name was Strasburger, and the brokerage was Valley of California Inc. They were one of the defendants, and obviously it went to the Court of Appeal. Now, here's the thing: when something goes to the Court of Appeal, people have money into it, right? A lot of money into it, and so in this case, and I want to highlight that. So this is the Court of Appeal of California, First Appellate District, and so this is the citation for the case. It's going to be the 152 Cal Appellate Level 3rd 90. So that's the legal citation. Notice the date here is 1984. So that's when it hit the appellate level. Okay, so what's the opinion? So Valley of California Inc. doing business as Valley Realty is the appellant, which means that they were unsuccessful at the lower court, and then now they're appealing that decision in the upper court, and so at the appellate level. So they appeal from a judgment for negligence entered in favor of the plaintiff, right? So and again, they were only one of 6 defendants in the cause of action. So what are the facts? So the respondent, that's Easton, purchased the property for $170,000 from the Strasburgers in May of '76. It took them 8 years to get this resolved, and escrow closed in July of that year. Appellant was the listing broker in the transaction. Okay, Valley Realty. Okay. Shortly after they purchased the property, Easton purchased it, there was this massive earth movement. And then later on, there were even more of those that destroyed a good portion of the driveway, et cetera, et cetera, et cetera. And there are actually some pretty good pictures of that online. So it turned out that part of the property was on fill. And so, as you know, there's a difference between cut and fill. Cut is where they cut into the ground. Usually it's much more stable. When they bring in fill, that means that they needed to shore up the property so they could put a structure on it or something along that line. And so fill. Cut is more stable than fill. Fill had not been compacted properly, and that's what the facts tell us. And so the foundation of the house settled, which caused cracks in the walls and warped the driveways. And so again, they paid $170,000 for the property, but the cost of repair took it to $213,000. Now, again, remember, this is before the TDS and before this other thing. So agents conducted several inspections of the property, and they were aware of certain red flags. So, for example, there was netting over part of the property to hold the soil in place, things like that. But they did not request soil stability and did not tell the buyer that there were potential problems. And so it was something that was very obvious to them that, when you're doing your Avid today, which Avid came out of this, right? When you're doing your Avid today, you're talking about the things that are obvious to you: a reasonably competent, diligent visual inspection of the normally accessible areas of the property. And so we're going to see those words in this case, and that's what your Avid says, that's what your TDS says. Okay, and again, we're trying to protect, legislatively, we're trying to protect the innocent buyer and seller, and the innocent buyer and seller by law is defined as the residential 1 to 4. So single family home, a duplex, a triplex, a fourplex, the law kind of thinks that they need special hand holding, and so we want to protect them. Okay, all right. So during the time the property was owned by Strasburgers, there was a minor slide in '73, but then a major slide in '75. And again, the fill dropped 8 to 10 feet in a circular shape. So they didn't tell, the unique part about this is they didn't tell anybody about it. They clearly didn't tell the buyer, but they also didn't tell the agents, their agent or the buyer's agent. They didn't tell them about that, about the slide or the corrective action. So the buyer purchases the property without knowing any of these things. Okay, so I'm going to fast forward here. The jury returned a verdict finding all the named defendants were negligent, and of course then the real estate, and they did what's called comparative negligence, which means they apportioned different liabilities to each party. And so the Strasburgers were 65%, probably because they were the only ones that really knew, and the agents were 5%. The jury also found a non-party, the cooperating broker, 5% responsible. Interesting, the cooperating broker wasn't held because they obviously didn't have any knowledge of it either. So we don't want to focus on we do want to focus on the judgment, but we want to find out how we got there. So there were a lot of problems in the case. The trial judge incorrectly instructed the jury on a real estate broker's duty to investigate, which later ended up becoming the law. No expert witness testimony was produced on two key issues. And there it is, standard of care, right? Standard of care applicable to the appellant. And again, that would be the real estate company and the appellant's failure to meet that standard of care. And that's what they would call me in on. The evidence presented was insufficient to establish that the appellant was negligent, and the jury basis award on the wrong measure of damages. So there's oh my goodness, we think we have problems today. Well, we just have problems all the time anyway, right? We have people being sued for no reason. It just happens. So anyway, so they're gonna reverse the original. None of the appellant's arguments require reversal of the judgment, but the appellant was improperly denied indemnification. So that's the whole principle behind all this. I'm going to go through this kind of quickly, but because you don't really need to like look at some of these cases are the basis for our statutory requirements today. Let's see if I can pull up. I'm looking for the Lynch case. And again, I'll send this to you. Go ahead and read it. And I'm happy to walk you through it if you want. Here's the Lynch versus Savage case. That was one of the first ones out there. Current law requires a broker to disclose to a buyer material defects known to the broker, but unknown to and unobservable by the buyer. Okay, so and we also have the Department of Real Estate regulations, and then the Cooper case, which was one of the original cases. It's the law of the state that where a real estate broker or agent representing the seller knows facts material affecting the value or desirability of the property. Does that sound familiar? Offer for sale, and these facts are known or accessible only to him and his principal. And the broker or agent also knows that these facts are not known to or within the reach of the diligent attention and observation of the buyer. The broker or agent is under a duty to disclose these facts to the buyer. And again, that's the Lynch case. So then fast forward from there, we've got a whole bunch of stuff going on. And I don't want to spend the whole day on this case. I think it's an amazing case, but the duty is implicit in the rule articulated. Speaks not only to the facts known by the broker, but also to and independently to facts that are accessible only to him and the principal. So let's definitely need to fast forward here. We're going to be here all day. So I've highlighted the key parts of this case. And let's see what I get out of that. Here we go. So the duty of the real estate broker, duty is reserved to the attorney, to the judge. I cannot even use that word in trial. I'm not allowed to use the word duty. That's the judge's decision. Representing the seller to disclose facts includes the affirmative duty to conduct a reasonably competent and diligent inspection of the residential property listed for sale and to disclose to prospective purchasers all facts materially affecting the value or desirability of the property that such an investigation would reveal. And when I'm talking to an attorney and they start rattling this off, I know I'm talking to a real estate specific attorney that knows what they're talking about. So, and again, in California, we have coined the term the QCREA, which is the Qualified California Real Estate Attorney. I've had people call me up and say, well, my attorney said this, and I've responded, well, I don't know, I teach attorneys this stuff. So where's your attorney? Oh, they're in Illinois. And so did they, I always ask the question, did they know you were asking them a California question? Because they could be disbarred for that. There's no way that an Illinois attorney is going to give a client advice on a California transaction. That's you lose your license, you lose your ticket for that. So okay. That being said, well, let's see here. Okay, so seller's broker, and this is the seller's broker in a residential real estate transaction is under a duty to disclose fact material affecting the value or desirability of the property, which through reasonable diligence should be known to him. And so now we're setting the standard at this time. This is 1984. Okay, so a very good year if you read the Aldous Huxley book. So because such agents are expected to make use of their superior knowledge and skills, which is the reason why they're engaged, and because the agents in this case were or should have been alert to the signs of soil problems earlier described, the jury was well within the bound of reason when it concluded that a reasonably diligent and competent inspection of the property would have included something more than a casual visual inspection and a general inquiry of the owners. Try to remember that when you are doing your avid. Okay. All right. Flying through here. I'm just looking to see if anything jumps out at me. There's some really good holdings as we go along here. Appellant's agents. So remember, the appellant was the the brokerage, were aware of the fill on the property and that erosion and settlement problems are frequently associated with such soil. They knew about it, right? Uneven floor and the use of netting to repair an earlier slide. So they had evidence, they were aware of the problem in the area. Again, don't call yourself a neighborhood expert, things like that. So scrolling down through here, I think we'll be able to cut this off fairly quickly. So anyway, the rehearing by the Supreme Court was denied. So not only did it go through the appellate court and not go well for the brokerage firm, but they tried to make it go to the Supreme Court, and the Supreme Court shot it down. So they said, we're not going to hear that case. You're done. So despite the absence of privy of contract, a real estate agent is clearly under duty to exercise reasonable care to protect those persons whom the agent is attempting to induce into entering a real estate transaction for the purpose of earning a commission. So absence of privy of contract could have been the seller's agent's relationship with the buyer, could have been that the buyer and the buyer's agent didn't have a contract. And I suspect that both are probably true. In the typical residential real estate transaction, however, the buyer may be intentionally or inadvertently led under such circumstances to believe the broker will represent their best interest, even where they're aware the broker has a listing agreement with the seller. Okay, so since the broker's commission is generally paid as a percentage of the sales price, the broker's interest is more closely identified with that of the seller than of the buyer. Remember that when you're thinking about that buyer representation agreement and who do you really represent. So remember, if you're the buyer's agent and you don't have the buyer representation agreement, the court's going to think that you represent the seller. And so even though the buyer thinks you're representing them, and that's kind of part of what's going on with the recent Burnett decision in the Midwest. So where the buyer is unappreciative of the potentially divided loyalty of the broker, he may be lulled into relying on the broker to his significant detriment. Misplaced reliance by the buyer can extend beyond the issue of price to questions regarding quality of title, condition, premises, et cetera, et cetera, et cetera. Okay, everybody good with that? So interesting holding by the court. I don't necessarily agree with it, but it's not my position. They're the court. Effectively, the buyer is unrepresented because of the problems of dual agency. So a purchaser of commercial real estate is likely to be more experienced and sophisticated in their dwellings. And remember the 1 to 4. Once I get to 5 or greater, now I'm in the commercial world. And in the commercial world, there is no civil code protecting the buyer and the seller. There's UCC, Uniform Commercial Code. And you see that today when you're dealing with issues of solar power systems on property. Those are UCC filings. Those are not, civil code. And I had a broker recently tell me that the information would come out in a title report, and I said, no, it won't. That's UCC filing. Shows up before closing because they want to make sure that they get their due, but it's not in the preliminary title report, and it was not in the preliminary title report. Okay, all right. So I'm not in this business to do the I told you so, but that was one of those very bad situations. So anybody have any questions about any of that? I'm going to go ahead and move up to the top. And so Easton versus Strasburger, I think a fairly decent case. Anybody have any questions? No, seeing none. Okay, so let's go back to the PowerPoint. And so as we know, we've discussed what the law says today about a reasonably competent, diligent visual inspection of the accessible areas of the property. Okay, so let's talk about the Department of Real Estate. And so the Department of Real Estate thinks, they have their own rules and regulations. And so some of the things that they talk about, and again, I did the podcast for them last Friday on the legal documentation necessary in a real estate transaction. I thought the podcast will be aired on the 29th of November, and I thought it went amazingly well. And it was because of the moderator, the person asking the questions was just a real professional. Again, the assistant commissioner for marketing for the Department of Real Estate. And so I just thought it was a great webinar or a great podcast. So they tape it, and then he's got to clean up all my bad language and stuff like that. And then they're going to air it along with the rest of what they're airing, which is kind of interesting. It's going to be the Department of Real Estate's program. I would actually like to show you that. So let me pull up the, where's my thing? So here it is. So I'm going to go to dre.ca.gov. There it is. And now I'm going to click on, and this is going to be important. So I'm going to click on consumer. And I'm going to click on First Home California. Oops, of course I spelled it wrong. First Home California, and it should be .html. Go. And I still got it wrong. First Home California .html. So I'm doing that incorrectly. Darn it. Consumer. Let me see if I go back to the department's website. Can I find it there? So, oh, you can't see this. I'm sorry. Let me pull this up so you can see it. So screen share. Here I am. Okay, I'm on the DRE website, and again, consumers. Here it is. And here it is, First Home California. Everybody see what I did? I hovered over consumers and I went down to First Home California, and I'm going to click on that. This is an amazing production. They really, in an interesting comment that they made to me, they said that the majority of complaints that the Department of Real Estate receives are from first-time home buyers. I thought that was really sad, a really sad statement. It means that either they're doing transactions with people that don't really care that they understand, or that they're doing transactions with people that the agent doesn't know what they're doing. And so a lot of times we don't know what we're doing. We think we're going to just kind of shine that on or pass it off, or not respond to their questions or things like that. And those are dangerous things on a lot of different levels. And I always step back to the market the way that it is right now. I don't care about how hot the market is. Our entry-level housing is critically important to us. And so most of our entry-level housing tends to be first-time home buyers. And so remember in 2003, when the affordability index in California went it was just way down. Nobody could afford to buy a house. And so what happened at that time? Well, we weren't watching. And frankly, and again, this is from my expert opinion on market, the entry-level housing market had come to a complete stop. So there was really no movement. The entry-level people just stopped buying. And so therefore we lost the move-up housing, and that was because it had just gotten prohibitively expensive. It's still prohibitively expensive, but the affordability index changes, from time to time, and that's based on essentially a buyer having 20% down on the median priced home in the area, and can they get a loan? And so there's a lot of reasons why they can't right now, and that's what happened in 03. Interest rates were good, but they couldn't afford the payment on the house. So and folks, I'm sensitive to that. I was knocking on doors when interest rates were at 24%. So I get it. Okay, but today interest rates are so high, I just can't believe we're still keeping them up there. Interest rates are so high, and the median price level of the home is up around $1 million. And so, first-time home buyers are having trouble getting into those properties. Interestingly enough, we've got transactions we're doing at $2 million, and they're flying off the shelf when we've got 5, 6, 7 offers on them, all cash. Cash doesn't care about interest rates, right? But then the $400,000 properties that we have, there's nothing. It's like crickets, right? So there's nothing going on there. So the sad truth of it is that's a lot of what we experienced back in 2003. And so what happened in 03 was the entry-level housing came to a complete stop. And then in 05, in August of 05 specifically, we know when, August of 05, all of a sudden the high end stopped selling. They just pulled back the braces and said, we're not doing this anymore. And so at that point, we realized that our entry-level housing, our essentially our median price homes at the time, hadn't been selling for a couple of years. And so we hadn't been fortifying that foundation that we need to keep our market doing well. Now, San Diego's got some exceptions to that, but literally we never saw it coming. And so we know that after August of 05, we started having all the foreclosures and things. And frankly, we don't have foreclosures in California. We have trustee sales. Foreclosures go to mortgages. We don't have mortgages. We have loans secured by deeds of trust. So it's a year of law school. You're not going to be interested in it. But the bottom line is that the market come to complete halt. And so now all of a sudden we've got banks, drinking water out of a fire hose, and so then the government had to step in, give them tax incentives for not foreclosing and not requiring the reserve accounts that they had to in the past and things like that. So these are big steps to try to get the economy back on track again. And so those are important things. So this is a great, the Department of Real Estate has done a great job on this, in my humble opinion, helping Californians buy their first home. I'm going to tell you, I know people that tell me I won't work with a buyer under $1 million. It's too much work. I love first-time home buyers. I mean, I don't understand that comment. I mean, I really, literally, they're more appreciative than anyone else is. Clearly, up at the high end, they're much more appreciative than the high end is. I prefer to work on the first time home buyer. I sold a $4.4 million home 1 year. I sold a $95,000 double wide the same year. And so, guess what? The $95,000 double wide referred 3-4 clients to me, and the 4.4, off they went. I never heard from them again. So anyway, the Department of Real Estate's created this really good website, and they've got a whole bunch of episodes in here. And mine's not up there yet. Mine's going to go up there on the 29th of December. They're pulling them out in increments, and so obviously you click on the links, and then it pulls these things up for you, and do's and don'ts, questions to ask the prospective real estate agent, what an agent does, reading the DRE license record, things like that. So really a good opportunity for you. I would say to refer your people to this website. Okay. All right. That being said, let me see. I had taken us away to, all right, we were talking about always be sure that you are using the current versions of the forms. And so how do you know? You look at the headers and you look at the footers of the forms to make sure you're using the right ones. And so we're going to talk about a number of these forms here today. And I'm going to go through them here really quickly, and then we're going to pull them up, and I'm going to show you what they are, and I'm going to show you how we fill them out, things like that. I can tell you that the Forms Tutor, Forms Advisor program came out of a class I was teaching at UCSD. I was teaching real estate principles at UCSD, and one summer they said, hey, you ought to be automating your process, right? And so they stuck me in a closet with a guy, and he's over there with a headset on, and he's got these sine waves going, and I'm over here looking at the forms, and I'm talking into a microphone, and I'm describing when do we use this? What is it? How do we use it? Things like that. And then we did all that. I still have the module saved. And CAR got wind of it, and they said, hey, we need to do that. And so it was a very small group of us that were involved in that committee, and you should really be using those programs if you're having questions about your transactions. Okay, so my disclosure regarding real estate agency relationship, that's the number one, the big daddy of all of them. That's going to be my California Civil Code 2079. The real estate transfer disclosure statement, which is if I'm going to get hauled into court, that's the one that's going to be it. Okay, so did they fill it out properly, the seller? And then the addendum, which is if they have to amend their disclosure, then they're going to use an addendum form. And then the agent's visual inspection disclosure, that's one of my favorite forms. And these, between the transfer disclosure and the agent's visual, I rarely have ever seen them filled out properly. Okay, so natural hazard disclosure statement, we don't even have the form for it anymore. We essentially figured that nobody was using the form. It was literally a snapshot of Civil Code 1103.7. And I mean, I think I'm going to reference these later, but that natural hazard disclosure, we saw everybody using third-party vendors for that. And it took away a lot of liability for the agents. But I'm going to show you how we get back into being liable again. Then we have the fire hardening and defensible space advisory and disclosure. And then we have the seller property questionnaire, the seller property questionnaire addendum. Then we have the federal lead-based paint disclosure. So the used to be the FLD, federal lead disclosure, but now it's the LPD, the lead paint disclosure. And then a quick review. So disclosures. So just generally speaking, let's talk about the different kinds of disclosures. And we've just shown you a couple of them, but my statutory disclosures are those disclosures that are required by law. Okay, and so statute, right? So when I say Civil Code 1102.3 and Civil Code 1103.7 and B&P Code 10167 or 10177, I'm talking about statutes. Okay, so the law requires it. So a statutory disclosures contain rescission rights. Okay, and so rescission rights means put the parties back in the position that they were in prior to the contract. Okay, so that's a very powerful word, right? In other words, make the contract go away. So in your head, you got to be thinking they get their deposit back, all that kind of stuff. There's really nothing to fight about because you didn't do the statutory disclosures in time. And so the law says, and if you take a look at the bottom of the transfer disclosure statement, and in fact, let me pull that up for you because I've got all these forms already pulled up. I've got it timed as to when we're going to talk about it. So here's the real estate transfer disclosure statement. So we're not there yet. I want to take you down to the bottom of page 3. And on the bottom of page 3, it says 1102.3, right? Of the Civil Code provides a buyer with the right to rescind a purchase contract for at least 3 days after the delivery of this disclosure if delivery occurs after the signing of an offer to purchase. What does that mean? That means that the buyer writes their offer, the seller counters the offer, and then the prudent real estate seller's agent has already had the seller complete all the disclosures, sends the statutory disclosures over with the counteroffer. The buyer loses the right to rescind the contract for 3 days because the court says you knew what you were buying. You got the disclosures before you agreed to it. So you already knew what you had coming your way. If it had happened after the contract, then the buyer would have had 3 days to rescind and cancel the contract. So that's a very important thing. So, I took a listing up in Lake Forest, a little bit north of San Diego here, and the sat down with the seller 3.5 hours. We went over everything. We went over all the statutory disclosures, the natural hazard disclosure, the transfer disclosure, all the statutory disclosures, and we had the seller sign all of them, complete all of them, and I advised and counseled them appropriately. And when the buyer's offer came in, we sent all the disclosures over with the counter offer, and the buyer's agent said, "I've never seen anything like this. This is like 88 pages of disclosures," and my response was, "Yes, it is, but understand that your buyer may not have the right to rescind the contract." And so, what was the buyer's response to that? The buyer said, "Oh my gosh, we've never had this happen before. You've told me everything about the property. I don't need 30 days. Let's close it in 13." And they did. They closed it in 13 days because we'd already told them everything. So this is a way for you to facilitate the process, be truthful with the buyer up front. In that transaction, we had a death on the property within the year. We had unpermitted additions in the property. The buyer was well aware of it when they accepted the purchase agreement, and so the rest is history. Now that transaction was a couple of years ago now, and the buyer has since sold the place and sold it to the next buyer. So a real estate broker is qualified to advise on real estate. If you desire legal advice, then you need to be talking to an attorney. Okay, that's the important ingredient in all of this. Okay, all right. So those are my rescission rights. Very powerful, very, very powerful at law. Parties may not waive a statutory right. So they may not waive the lead paint disclosure. They may not waive the TDS. All right, but that's a statutory disclosure. Okay, then we have contractual disclosures, and a contractual disclosure is one obviously created by contract, not created by statute. And any questions so far? Okay. Contractual disclosures contain cancellation rights. So statutory disclosures contain rescission rights. Contractual disclosures contain cancellation rights. And what does that mean? That means maybe an opportunity for the parties to exit the contract without penalty. Maybe. Okay, so let's talk about a statutory disclosure. TDS. You give the buyer the TDS on day number 18 of the transaction. They got 3 days to cancel. Okay, the buyer does so again, those are specific terms. Cancellation right would be more closely associated with something that they do in the contract. So for example, they do a physical inspection on the property. The physical inspector notes items that are of concern in the transaction of the property itself. So let's use an example. The lights in the kitchen don't work. Okay, so now Does that allow the parties to cancel? And the answer is no. Maybe, let's say maybe. So it must be a material fact affecting the value and desirability of the property. So if the fact that the lights aren't working is because the bulbs don't work, the court's never going to hold that to be a material fact. Okay, and so probably not be able to get out of the transaction. Okay, whereas if it had been a statutory right, they could have, right? But secondly, what happens if instead of the light bulbs just aren't working, the light bulbs are no good, that it's an actual electrical problem? Now we're starting to get into a material fact. Okay, so those are the kinds of things that the court weighs, and those are the kinds of things that you can't make a decision on. So you don't ever want to tell a buyer that they get their deposit back, or I can get you back your deposit, or I can get you out of a contract for any reason for 17 days. I had that challenge with a broker where the broker said, we're canceling contract. And I said, why? And they said, because we can. I said, excuse me? And they said, well, yeah. And I was management for a very large firm in San Diego. And so he says, well, because I have a 17-day free peak. And so I said, man, you're back in the 90s. I would never use that term. There's no such thing as a free peak. A free peak meaning we have a certain amount of time in which to cancel for any reason. And that is not true. It has to be a material fact affecting the value and desirability of the property. And so I kind of, I didn't tell him what he had to do, but it took him about a week to figure it out, that he needed to come up with a valid material fact affecting the value and desirability. None of this we're getting out of the transaction. No, you're not. It takes two people to put the contract together. It takes two people to take it apart. My job is to keep this from going to litigation. That's what I did for the company. And this is one where if you can't come up with a good reason, and I didn't tell him that, but ultimately he figured it out and we let him out of the contract. So it has to be a material fact affecting the value or desirability of the property. But that's how you get out of it. Cancellation right. Again, people call me all the time trying to get out of contracts. And I said, I'm not going to help you do that. I'm not going to help you break the law, for one thing. And for another thing, that would be a tort. That would be interference with contract. So I clearly can't advise you on that. You need to talk to your attorney about that. Okay. All right. I had it happen personally. I was selling a property in the Bluffs in Del Mar, and it was my seller and my buyer, and I was dual agency. And I should make a note of the fact that dual agency, we all get excited because then we get paid twice as much. But the fact of the matter is, our liability can go up two and three times as much. So it may sound like a good idea, but even in our office, we really don't like dual agency. But we do have situations where we're going to be dual agents, and so we will divvy up the seller's agent represents the seller, the buyer's agent represents the buyer. It is still dual agency because it's under the same broker, but we're going to create a shield that'll be fairly easy to defend. Okay, so let's go on to the forms. I want to show you. Let's talk about a couple of these. We're going to talk about the disclosure regarding real estate agency relationship. You'll notice there's no S on the end of it, even though the purchase agreement paragraph number 2 has an S on the end, so it's a problem. But it's CAR form AD, and it is California Civil Code 2079. So let's take a look at this. I'm going to take us over here. We're going to cancel the Easton case. Do you want to say the changes? Sure. And now we're into our disclosure regarding real estate agency relationships. So again, this is Civil Code 2079. You see that over here. And notice that we changed the language of the legislation. We literally went in and petitioned to have the law changed. So we remember it used to be called the listing agent and the selling agent, and that just confused so many people. It was funny, Lynn and I were talking about it today, but now we changed the language to be the seller's agent and the buyer's agent. And I'm glad we did that because that now we're writing things in plain English, something everybody can understand. I always got such a kick out of it because it was actually tested on the state exam, where they would put in, they would just spin things around to try to confuse people, and they were pretty effective about that. And listen, if we didn't understand what it said, clearly we couldn't explain it to the buyer and the seller. Okay, so this talks about the seller's agent's fiduciary duty to the seller. This is what talks about their mutual duty to both the buyer and the seller. And then the buyer's agent has, here's their fiduciary duty, similar to the seller's, right? And then here's what the buyer has between this is what the buyer's agent has between the buyer and the seller. So you can see that those are fairly mirror each other. But again, I don't believe that you are the agent for the buyer unless you have a written agreement with them. I think you are that they are your customer, not your client. And again, I teach this on a number of different levels. So here's what the agent representing both the seller and the buyer do. I think this is a must read. At some point, you have to spend a minute and actually read this form because it contains a lot of really good information that you probably would never know because you just had people sign it because it was too complicated for you to read. Well, if it's too complicated for you to read, it's probably too complicated for your client to read. And so you need to talk to your buyer or your seller about this. Again, it includes provisions of 2079, and page 2 is going to be the specific conditions. We'll look at that in a minute. So this is just acknowledging a receipt of the copy of this disclosure and the portions of the civil code printed on the second page. And so I really like the portions on the second page, probably the smallest print you're ever going to see, right? I remember I was asked by the California Association of Realtors back probably 25 years ago to proof this document, and it might have been longer than that. And I went through it looking for legal, veracity, for grammar, for spelling, and essentially I was reviewing the civil code. And I did find one mistake down here where it said agents. It was actually spelled agnates, and so I think spell check could have caught that. But it was the only mistake on the whole form. I was really impressed. And so been a couple of changes since that time, but the substantive ones we've addressed those already. Okay, so that's my agency disclosure form that you know of. I do want to make one more note, however, though. So remember that the law requires that you disclose the concept of agency, and that's what this form does. It discloses the concept. This is what agency could look like. Because when I take a listing, I know I'm a single agent. I don't know where the buyer's coming from yet. I don't know if I will be into a dual agency situation until the buyer comes along. And if I'm the buyer's agent and I've signed the buyer representation agreement with the buyer, I don't know until the buyer tells me what house they want to buy, whether or not they are going to buy a property that is listed by my broker, putting me into dual agency at that point. So there's those two competing interests, and I can tell you that the different states handle this differently, but in some states where I teach, the buyer can say, I don't buy that. I'm not doing that. I don't want you to be my agent. I know I have a contract with you, but the law says I don't have to let you be my dual agent in this transaction. So again, you need to be really clear. And again, I do a lot of trial work on this, really clear on the concept of agency. So the law says that you must disclose the concept of agency, and that's what this form does. But then the law says also you must confirm agency, and that's what we do when we write our offer on the property. And so paragraph number 2B is the part where you check the boxes confirming agency. So you must disclose the concept, but you must also confirm. I frequently see that part done incorrectly. So where agent did not check the boxes as to who they represent, or the DRE numbers were incorrect. So now that's going to be a problem for a different reason. The DRE numbers being incorrect. So sometimes the software loads the broker's MLS number. So you got to be attentive to that. Make sure that that's not what's happening. Okay. All right. Everybody good with that? Any questions about any of that so far? That's always my excuse for getting a drink of water. Anyway, okay, so that's my agency disclosure. And again, I've really kind of cut it down to its nubs, so to speak. It's obviously a very complicated issue. So, but you must disclose the concept of agency prior to committing conduct that constitutes agency. And I am aware of a case in San Diego where the broker represented the buyer, and then another agent came in with the seller. I'm sorry, yeah, vice versa. The transaction coordinator discovered that the agency disclosure had not been done, and this is before we added these to the forms. You really can't miss it, right? But I've seen people try to circumvent it by printing it and then providing the other stuff without the agency disclosure. But the point is that the agency disclosure had not been made. The Department of Real Estate and the transaction coordinator discovered the mistake the day before closing. the Department of Real Estate, and then it closed. The Department of Real Estate stepped in and said, we just think that's way too late. And I have to agree, because what? You're supposed to make your disclosure prior to committing conduct that constitutes agency. Well, they had gone through the entire transaction all the way to the end. And so, and they took, it was a $66,000 commission. They took it away from the agency. So they did not get paid in that transaction because they felt that that was egregious. Okay. All right. So that's my point on my agency disclosure. Then we talk about the real estate transfer disclosure statement. And again, one of my favorite forms, and that's the TDS, and Civil Code 1102 is going to cover that. So let's pull up my TDS. And that's going to be the form that we briefly talked about earlier. Up the top, 623, make sure that you are using the current revision of the forms. And so again, remember I said this in the very beginning, you want to make sure the current version. So up at the top in the header, it will tell you the year, and we updated a lot of forms. Now, the big update that occurred in 2023 in June of this year was this property is a duplex, triplex, or fourplex, and TDS is required for all units. And this one is for all the units or only units numbers, 1 and 2, but not 3, that kind of thing. And then when I get into my city, obviously the city of, the county of, and then the physical address of the property. This is not the legal description of the property, it's the physical address of the property. And so for purposes of contract in California, we allow you to put the street address in there, even though you're going to have the legal description to transfer the property at some point. Okay. All right. So the date here, I frequently do contracts and review them, and I find that the date is not included. The date you put in there, the date that the seller is completing the TDS. Okay, not the date of the transaction. Now, the law changed last year to say that the whatever the disclosure requirements were that were in effect at the time of contract, that those will remain in effect throughout the term of the agreement until closing. What that means is that if the TDS changes mid-contract, then there's no requirement to use the new TDS. Okay, all right, that's all that means. I've got a really good Q&A from CAR on the substituted disclosures. It'd take me too long to find it here, but essentially what it says is that we have these two check boxes nobody ever checked, and so we needed to make sure that this paragraph was being read. So we created a third one that is in most of your transactions, you're going to check this box that says no substituted disclosures. And again, if you want a copy of that Q&A, send me an email. I'm more than happy to send it to you. It's a great breakdown of the purpose behind the legislative change and what we had to do with it, frankly. Seller's information, paragraph number 2. So the seller would complete the box, are they or are they not occupying the property? Most sellers know if they're living in the property or not. If it's a second home or whatever, that doesn't reduce their liability, but they would say, I'm not occupying it, or I am occupying, whatever they're going to answer, that's their answer there. They need to be truthful about that, and you do not want to be filling this out on behalf of the seller. I had a case where the attorney asked the seller, is this your disclosure? And this was back before, when we could actually fill it out on zip forms, WIN forms at the time, I should say. And the seller said no. And the attorney says, well, whose is it? They said, well, the agent filled it out, and then I initialed it and signed it. And so the attorney said, well, but did you read it? And the agent of the seller said no. And so, it became the agent's disclosure. And so I made a comment in a WIN forms meeting advisory committee. I was on that since it came out. And I said, we really need to be undoing this so that they cannot check those boxes. And so sure enough, they fixed it on the TDS, they fixed it on the FERPTA, so that the SPQ, the SPQA, we've made it so that the agent can't fill it out, but when you send it for electronic signature, the seller can fill it out, seller can complete it. And that's the intent behind the legislative process. So seller checks the boxes on things that that are included in the transfer, including down here. This is frequently missed. And then they answer the question: are there, to the best of your seller's knowledge, any of the above that are not in operating condition? Yes or no. So if the failure to answer that question, yes or no, would make this a defective TDS. And so remember that it's a state exam question again. The buyer can sue for 2 years on a defective TDS. So we want to make sure I'm always looking in this. Whenever I get a TDS from the seller's agent, I'm always looking here. And if it says yes, I'm looking for an explanation. Okay. All right. So if it says no, then no explanation, but we're hoping that no means no. Okay, then I have, are you, seller, aware of any significant defects, malfunctions in any of the following? And so, whereas A listed the items in the property and then asked the question, and B, we're going to ask the question and then list what those are. So kind of backwards, but I can't speak for the legislative body. So, so we're going to talk about interior walls, ceilings, floors, insulation, Easton foundation, slab, driveways, things like that. So if the seller's aware of something, and this is the question I always get, is that we don't know. Well, I don't know is no, you're not aware of something. And so again, it's the seller's disclosure. So if the seller says, well, I don't know if there's anything, well, then the answer is no. Right. But again, as I said in the beginning, I've really never seen one of these filled out properly. When I look at paragraph number, well, again, obviously, if the seller says yes to anything, I want to see that described here, what that yes means. Okay. So then there's a couple of things that happen in the transaction. I'm going to talk about them in a minute, but this is my child resistant pool barrier, the automatic reversing device standards and things like that. And again, when I go to Civil Code 1102.3, this is a picture. They took a picture of that and they put that in here to the document with a CAR letterhead on it. CAR didn't create it. It is the legislation on the subject. And so scrolling on down, I've got things about water conserving plumbing fixtures, after January of 2017, et cetera, et cetera. Paragraph number C, again, and I had this conversation with an attorney last night. In paragraph number C, I frequently get these from the seller that just have no checked all the way down through it. That's the seller saying, I don't know anything that's wrong with the property. But it also tells me that the agent didn't take the time to sit down and counsel the seller about the questions and the answers to those questions. Okay, so again, are you, seller, aware of any of the following? Yes or no. And so paragraph number 1, we added the word mold probably about 20 plus years ago, so that you really couldn't answer no. I still see an answer no. I don't get it. It's okay. We put that in there so you couldn't say no. All right. Features of the property shared in common with adjoining owners. Most all the properties that you sell are going to have a fence that nobody knows whose it is, things like that. I would say that's going to be yes in a lot of our transactions. Encroachments or easements or similar matters. And so, I don't need to go through what an encroachment is. Something that invades onto the property. It can be water, it can be tree stumps, it can be a lot of different things. An easement is the right to use the property of another. So, but we have all kinds of separate types of easements. But all properties have easements, right? I mean, you have utility easements, you have fire safety, law enforcement. All properties have easements. So I think that is going to have to be a yes answer. 4 and 5, was anything done to the property without necessary permits or anything done not in compliance with building codes? Simple questions. The seller should know whether those things happened or not. Paragraph number 6, sounds like Easton, fill, compacted or otherwise. That was Easton, right? Any settling from any cause, right? Flooding, drainage, or grading problems. And so typically we put our rose bushes around the base of the house and then we water them, which ends up causing the concrete to deteriorate. So, could potentially be a drainage problem. Major damage to the property, any zoning violations, non-conforming use. Remember, a non-conforming use is one that was legal at one point, but then the code changed around it. They would perhaps have the ability to continue doing what they were doing, but they couldn't come in after the code change to start doing it. Neighborhood noises, noise problems, or other nuisances. So my house is oceanfront in Del Mar. Train runs right in front of it, right? So, the first time I heard that, I thought that the world was coming to an end. As time has gone on, obviously, I've gotten used to it, but I still have to disclose it. Same thing with the helicopters. And so I always used to teach in my college classes. I would always teach that the pilots, the Marines from Miramar, their eyesight was better in the winter than it was in the summer. So in the winter, they were out a mile out to sea, which is where they were supposed to be. But in the summer, they were right across my window. If I can read the call sign on your helmet, then you're too close, right? So the joke was that what are they looking for? They've got the beaches, they got people on the beaches, in various stages of undress, stuff like that. And so that's why they were always flying closer in the summertime. So I had this argument with Duke Cunningham at one point where he says, Kev, he says, that's the sound of freedom. And I'm like, I know, but it's in my doorstep, so it's loud. So I would, the train, you need to be disclosing those things. The helicopters, you need to be disclosing them. Barking dogs, CC&Rs or other deed restrictions. All properties have deed restrictions. My house is 800 square feet. I used to joke with Linda that you had to go outside and change your mind. But can I build a 16-story high-rise there? And the answer is no. That I've got deed restrictions that prevent me from building. In fact, in Del Mar, you really can't do much of anything without having some kind of a permit for it. So homeowners association, yes or no? I don't have any on mine. Any common areas, yes or no? Any notices of abatement or citations against the property? So a notice of abatement says, clean this up. A citation is a ticket. The fire department can come by and you've got your weeds overgrown. They can issue a notice of abatement. If you don't take care of it, they can have somebody come in and take care of it. And then they just give you a bill for that. And then they put it on your tax, your taxable dues, twice a year you pay your taxes. And so, the county can foreclose on your home for not cleaning up the potential fire hazard, things like that. Okay. Any lawsuits by or against the seller threatening to or affecting the property. And again, we just want you to explain what those things are. Paragraph D at the bottom of page 2. The seller is going to certify that the property will be in compliance. Again, this is the seller certifying this health and safety code by having operable smoke detectors, which are approved, listed, and installed in accordance with state fire marshals regulations and applicable local standards. So I do not need a smoke detector statement of compliance when I've got a current TDS being used in a transaction. Okay. The second part of it has to do with the water heaters. I do not need the water heater statement of compliance if I'm using the current version of the TDS. Okay. All right. So, and then I get to page 3. And so remember that the law says that the TDS is not considered complete until the seller's agent provides their disclosure, their avid. Okay, so the agent would check the box that says see agent's avid, attached avid agent visual inspection disclosure form, and then they would sign it. So the TDS is not complete. So 3-day right of rescission applies until this form goes over. Just had a transaction where the seller's agent didn't provide it for 2 weeks into the transaction. There was no real TDS until it was provided. Okay, everybody good with that? All right, and then paragraph number section 4, the buyer's agent would complete that again, but the seller's agent is the integral part here, and then and only then will the parties acknowledge receipt of the above. I frequently see these come back to me where the seller has signed everything, including down here, before the buyer's agents even completed their portion of it. So that needs to happen first before the seller signs down here. Anytime you see signatures stacked, they are signed in chronological order. Anytime you see them side by side, it doesn't matter who signs first. So in this form, it won't matter whether the buyer or the seller signed first, but it does matter that the seller's agent signs first up here, and then the buyer's agent signs second. And then down here, I'm going to have the seller's agent sign first, and then the buyer's agent sign second. Everybody good with that? Very, very important concepts there. I want to make sure we covered all those for you, but that's my TDS, one of my favorite forms. Then I have an addendum, and the addendum is intended that if something changes during the transaction, we'll just talk about this really quick. If something changes in the transaction. So here's my addendum. Notice up here it says transfer disclosure statement. So we're making an addendum to the transfer disclosure. Remember, the buyer has a 3-day right of rescission upon receipt unless it's given to them prior to the transaction being consummated, and in which case they have no right of rescission. But then the seller comes along and has to amend their TDS. So I always use the example: the police chase the bad guy into the house, shoot and kill him dead. The seller, now Civil Code 1710 says that the seller must disclose the death on the property within 3 years. And so now we have to amend the TDS, and amending the TDS also gives the buyer a right to rescind the contract. So use this judiciously. If there is a disclosure, you definitely need to make it. You don't want that to come back to you. But remember, again, it's the buyer who sues. Okay, everybody good? All right, and that's my addendum form. So I'm going to close the TDS. I'll leave the addendum up there so I can make a nice gradual introduction there. So my addendum form is the ADM form. Then I have my agent's visual inspection disclosure, and that is CAR form AVID, and that is from the Civil Code 2079. So we talked about this briefly a minute ago, but here's my AVID. I really like the AVID. And so again, remember, there's one for the seller's agent, one's for the buyer's agent. If there is no buyer's agent, then obviously there's no second AVID. Remember that the agent must complete this even when a TDS when the seller is exempt from completing a TDS. And so I'm getting a lot of cases now where the agent has said that the seller is TDS exempt. And I said, on what authority do you have that you're making that comment? I had one broker send me a picture of a magazine article. I had another broker just recently, quote me the language in the ESD form, which, it's not my position. It's a legal decision as to whether or not the seller is TDS exempt. And typically the seller will have something from their attorney that talks about that exemption. Okay, so what I do is I make repeated attempts to get it. I get shot down every time, but those all go in my file so that I can say later on, I can defend myself from my own buyer by saying that we kept asking for it, they didn't provide it for us. And so TDS, the AVID is a wonderful form. In the old days, what people would do is they would fill in the language on the TDS on page 3, recommend physical inspection by licensed contractor. We stopped doing that about 25 years ago. I did get a transaction recently where the broker did that, and I was like, really? So that's one of those things. We just kick it up to the DRE and have them educate the agent. So you would fill in the name of the firm, obviously the street address of the property up here. I would recommend at some point that you actually read this language. Make sure that you don't do things that are inconsistent with it. And notice the admonitions about the roof and the attic and the interior and the exterior and all that stuff. And then I read this to you already earlier, what this means to you. That's right. I also pulled it up, I think, in this morning's class on the top 10 risk avoidance techniques. So that being said, I scroll down here to the top of page 2, and it could be for a particular unit rather than the whole duplex, triplex, or fourplex. The inspections performed by, I would have the company's name in here again. Date and time are important. Let's see, do I have that open on my computer? No, I don't. Okay, all right. So date, oh, you can't see that anyway. So date and time are important. Other persons present. You need to put in the names of other people that were there, because those are going to be your witnesses in the event that you're challenged. And if you put in weather conditions, clear as a bell, and plaintiff's counsel goes back and looks at the weather that day and it rained 3 inches, you're going to have some credibility problems, and so you'll have some DRE issues for sure. So the undersigned, based on a reasonably competent, diligent visual inspection of the reasonably and normally accessible areas of the property, right? Sounds like Easton again, right? And so in here, if something doesn't apply, then you do NA. If something does apply, but you don't see anything of note. So living room, I didn't see anything that jumped out at me. So there you put nothing noted. So NA is not, there's no such room. Nothing noted is there is such a room, but we didn't see anything in it that jumped out at us. Okay, real simple. Again, remember that when you're making these disclosures, you want to disclose, you don't want to diagnose. So the failing is in the diagnosis, okay, because you are not qualified to do that. I mentioned in this morning's webinar a really good lawsuit where the buyer and the buyer's agent were at the subject property. It was a harbor front property in, I think, Balboa. And the buyer asked the buyer's agent, it was low tide. Buyer asked the buyer's agent, what does the stem wall look to you? And the buyer's agent said the stem wall looks fine to me. Well, the buyer's agent thought he was looking at the stem wall because it was low tide, but it wasn't. That wasn't the stem wall. So I learned more about stem walls than I ever care to admit to. And that was a very expensive lawsuit, millions of dollars in lawyers' fees on both sides. I was able to save the day for the brokerage firms, but again, don't make representations outside of your wheelhouse, or the DRE mentioned that to me about this is my wheelhouse to be talking about legal documentation and transactions. So keep it within your standard, keep it within what your experience is, your licensing and all that kind of stuff. Everybody good with that? That's page 2. And then again, I get down to page 3. And of course, I mean, I've never seen a driveway that didn't have cracks in it. So, mine are almost always going to say cracks noted. I'm not going to diagnose them. I'm not going to say normal settling cracks. That would be a huge mistake. I'm not going to say minor settling cracks. Those are diagnoses, right? I'm embellishing upon the fact that there's a crack. Just say crack noted. I mentioned it this morning in the class. I had a lawsuit where the agent had gone into the bedroom. They saw a stain in the ceiling, so they noted, water stain noted in northeast corner of bedroom number 2. And then after closing, the buyer goes into the attic to, fix the water invasion. Turns out it's paint cans. Hazmat gets involved. That was very expensive for the brokerage because, they diagnosed what it was. It wasn't water. So you should not have used the word water. Okay. All right. Mold, mildew. Do you know the difference? And the answer is most of us don't. And so mold is gold, as we say, and it's a very particular word, and it tends to be emotionally based. But you're not qualified. I was at a physical inspection for a property where the inspector and I had been really good friends. He's since passed away, but we were inspecting a property, and he opens up the door to the heater room, and I'm looking at this heater wrapped in I have a graduate certificate in hazardous materials management, and so I'm looking at it, I'm going, uh-oh, and he's looking at it, and he turns to me, and I'm turned to him, and he says, okay, I'll make a note. We didn't have to say anything, right? And so he made a note in his thing. He says, this needs to be investigated further by the buyer, for potential for asbestos. It was a wrapping around the heater. It was very common. This house was built in 1948. It was very common. Asbestos tends not to be a problem unless it becomes friable. People do it, tenants do it all the time. They screw the planter hook up into the ceiling of a cottage cheese ceiling, and they've just released all those asbestos fibers. And so I'm looking at this, buyer orders an investigation. Sure enough, it's asbestos. Now you had a professional, OSHA certified professional that said that is asbestos. And it went up into the ceiling and then 22 feet across and then stopped for some reason, but they determined that it went all the way that far. They asked the seller to pay. It was a $2,800 fix. The seller refused because they thought the market was in their favor. And ultimately the seller sold the property for about $350,000 less than this buyer was willing to pay for it. And this buyer, my buyer, happened to have a friend who had passed away recently of asbestosis. So, it's not incredibly common because we've kind of encapsulated all this stuff, but that just didn't sell. And to this day, the agent's angry at me, and it's like, hey, I don't know what to tell you. And the agent was the owner of the property as well. So, you should have done the $28,000 or $2,800. It was such a small number, it was crazy, but they wouldn't do it. So I was like, okay, all right. So this disclosure is based on a reasonably competent, diligent visual inspection of reasonably normally accessible areas of the property on the date specified above. They just love those words, don't they? Notice that it says firm who performed the inspection. I think it's to say firm that performed it, but all right. Signature of associate licensee or broker who performed the inspection. Okay, so now if you didn't perform the inspection, you don't sign the form. So in a particular case that I had up in Lake Forest, one of our brokers, Joe, accompanied me while I spent 3.5 hours with the seller completing the disclosures. He went around the property and did the visual inspection, did a great job on it, and he signed off on everything, but I didn't do it. So I'm not signing it. And this is what the DRE is looking after right now. The DRE is going after real estate teams where the member of the team goes out and does the inspection and then brings it back, and the team leader signs off, takes credit for it. So that's what they're looking at. Who performed the inspection? And so the DRE, in their words, they said, we think that's fraud. So I always say fraud is like a 4-letter word, right? I mean, it may be 5 letters, but it's a bad word. And if the DRE says it's fraud, listen, I'm paying attention, okay? I mean, that's going to be an important thing. So I would only sign something that I actually did. And so this paragraph says that real estate agents are not home inspectors or contractors, so don't interfere with the inspector. If the inspector goes right, you go left, okay? And that's just a rule. And then if the inspector comes up with something, don't you go shooting it down, say, he doesn't know what he's talking about, or you could fix that very easily, or something like that. Do not get involved in that. Remember, they have insurance separately for what they do. You don't have insurance as a physical inspector. Okay, the buyer then signs it. The seller could or maybe not initial it. It just depends. And then the seller's agent signs it, and the buyer's agent signs it, and we're done. And that's the AVID. And so the AVID, like the TDS, is 3 pages. I always say it's 3 pages of happiness, but it is literally written to protect you. Okay, so make sure that you're doing that. Make sure you're using the form properly. Make sure you're explaining it properly. Okay, all right, let's go to, so this was my AVID, and that came out of Civil Code 2079, which came clearly out of the Easton case, all right? So remember, the TDS is not complete until the seller's agent's AVID is delivered to the buyer. All right, everybody good with that? Good. Let's talk about my NHD, and that's Civil Code 1103.7. There is no CAR form for this. We retired the form, the reason being that nobody was using it. I mean, we actually look at the library, we see nobody's using it. Most everybody was relying on a third party to do it, so we just eliminated the form. And again, much like the TDS, the form was a picture, a snapshot of the statute. We would not recommend that the seller make the disclosure. If the seller makes a mistake in the disclosure, then the courts have held that if you said it's not in the zone, and in fact it turns out to be in the zone, excuse me, then they have no choice but to award the cost of the home, right? Because you can't, if the home is in the zone, you can't move it out of the zone. And so I always defer on the side that it is in the zone. So again, California has 6 zones identified by the state to be hazardous zones. So 2 earthquake, 2 fire, 2 flood. So let's take a look at that form. Probably have to go flying through that one, but let's pull up the form really quick. So that was my AVID. Let's take a look at my NHD, and I thank you to this company for providing me a copy of the report. And notice they do a pretty good summary page up front, and then the actual report itself. So we get down in here, and here's, remember what I said earlier: 2 fire, 2 flood, 2 earthquake. So here's my 2 flood, here's my 2 fire, here's my 2 earthquake. So now they specifically tagged it was in a very high fire hazard severity zone. And we're going to talk about that in a second when we do the fire hardening disclosure. And they said yes. And so depending on whether it's in there or not, and so what we've done is we've tasked the natural hazard disclosure companies with actually doing the work for us that we were having to do before. So now they actually look up the property and whether or not AB 38 is required. And so I've got a transaction right now that's apparently very confusing for the broker associate, but we still don't have an AB 38. We closed a week ago. So I've got a file full of requests to get that AB 38. So in this particular transaction, the disclosure was voluntary. In the other transaction, it was not. So again, very significant legal thing. So the seller will sign it first, then the seller's agent will sign it, and then it'll have a notation of who the third party vendor was. Make sure whoever you use, make sure that they have insurance to cover you and to protect your broker. And then the buyer signs it. The buyer's agent does not sign it. The buyer's agent is tasked with delivering it, but they don't necessarily have to sign it. Okay, everybody good with that? That's my NHD. So let's pull up my. I want to. You kind of saw a sneak peek back over here. Where it says, there we go, the NHD, there's no form. Then I have my fire hardening and defensible space advisory and disclosure. And so that's CAR form FHDS, and that's Civil Code 1102. So we're back into the TDS, we're back into the 3-day right to rescind. Okay. So let's take a look at that. And so the new form came out in June of 22. And remember what I said now, that the natural hazard companies are tasked with actually, telling us whether or not this is going to apply. And so, I have several sections. This section number 1 is intended to tell you whether or not you need to complete the form. So number 1 says if these 4 things are present, if any of these 4 conditions is not met, seller doesn't have to answer the questions in 2B. Okay, that's the first part. That's 1A. Okay, so here's 2B down here. Don't have to answer these questions. All right. Let's take a look at 1B. So defensible space compliance. So it's the same as 1A, except we've removed the January 10th, 2010 requirement. So then that means that it can be any date at all, in which case the seller would have to complete, seller would not have to complete paragraph 3 if any of the 3 conditions up here are not met. So again, I like the fact that we have legislated having the natural hazard companies look this up for us. Turn that down a little bit. And then finally, my paragraph number C is my fire hazard severity zone status. And so obviously in this case, yes, it fell into the zone. Okay. Fire hardening disclosures if necessary. And then we have the rest of this form, which we're just not going to have time to go through it. I spent a whole hour on this form when I'm teaching this class, so it's significant. Down at the bottom, they've got a really good tree, they call it, defensible space decision tree. I wish that these fields were interactive, but they're not. But again, as I said, the natural hazard companies who have actually access to the database are going to be required to make this disclosure for us. And this is one of the reasons why CAR pulled the December releases that were coming, and I'll be doing for sure. I'll at least be doing a podcast, if not for San Diego Association, at least for my podcast purposes. That's why you need to be getting the newsletter to make sure that you know when those are coming. But I will be doing some updated podcasts on things that'll be even more interactive. Okay, so all right, so my defensible space decision tree, fairly extensive, covers a lot of different things, and so I kind of like it. It's hopefully it's been very confusing for people, but you don't want to make the mistake. And part of the reason is that if the seller, for example, let's go back up here for a second. If a lot of times the seller's agent tries to get the buyer to agree to do things that they wouldn't otherwise have been required to do. Here's the problem. The buyer has a year to do what they're going to do to bring the property into compliance. So the risk to the smart guy real estate agent is that if you do that to the buyer, and then after closing, they discover that the property can't be insulated, or that it's going to be $50,000, prohibitively expensive, they're going to come after you. So it's like, I really think that this should probably be done by the seller, and most sellers are doing it anyway because it just makes sense. But I don't agree with passing it off back to the buyer. Okay, all right. That being said, let's go to seller property questionnaire. And so the seller property questionnaire actually came out of San Diego. So San Diego Risk Management Committee had created a form called the SAD, which is the seller's additional disclosures. And so they used it for a couple of years, and then California came along and said, wow, that looks like a really good idea. So some people think they copied it. I'd like to think, no, that we offered it, which is not 100% true, but California came along and created a great statewide form. I mean, I like the SPQ. Listen, I'm looking forward in trial, but the SPQ is a great form. Essentially, the SPQ is not a statutory form; it's a contractual form, and it tends to unpeel the onion that the TDS started. So the TDS again is a statutory form, but it misses a lot of things that are required by statute. So, for example, death on the property. And so, death on the property within 3 years, and that would be the exempt seller disclosure instead of the TDS, but they can also fill out the SPQ, which I would recommend, but I seem to get pushback on that. But again, Civil Code 1710, you must disclose the death on the property within 3 years of the death, et cetera, et cetera. Okay, so that's not included in the TDS, and so the SPQ kind of unravels what the TDS missed. Okay, all right. So let's take a look at that SPQ really fast. We won't have a whole lot of time on it. Who's missing? Linda, come back. Okay, so we'll go to the SPQ here. Oh dear. So my seller property questionnaire. Again, look at that revision date, 6 of 23. Very important. And so. Again, we made the changes consistent with the TDS across the top, and then they discuss seller's awareness. So what does being aware mean? So a yes answer is appropriate no matter how long ago the item being asked about happened or was documented unless otherwise specified. Explain any yes answers. I find that the sellers do not read this, and that creates its own set of problems. I'm frequently sending these over to the seller. I like being on the phone with the seller, going over with them how to complete it. And the DRE likes it when you do that too. So it really is kind of an important thing to do. And so, but I'll frequently, from the seller side of the transaction, they'll send us the SPQ. There'll be yes answers that aren't explained. And remember, it says, just like the TDS, are you, seller, aware of? And if you're not aware of something, then the answer is no. But if you are aware of something, well, then clearly check yes, and then clearly explain it. That's all. And so I'm frequently having them redo the SPQs because they tend not to get that all done properly. So then I have in paragraph number 6, I have my statutory, where's my microphone? I have my statutorily or contractually required or related, and this is the part from the ESD. So within the last 3 years, the death of an occupant of the property upon the property. And so I want to make special note, excuse me. So we showed the Heaven's Gate property in Rancho Santa Fe. And so 40 people, 2 weeks later, 40 people off themselves in the property. And I'm not making light of it. I mean, it was a serious situation, but obviously a mass suicide. I believe, I mean, that's what I was told anyway. They drank the elixir and they had purple shrouds on their heads and stuff like that. So everybody killed themselves. So is there an obligation to disclose the death on the property? And the answer is yes. The city of San Diego came in and changed the street name to try to unstigmatize it. The seller had been on the market at 2.2 million. It was tenant occupied, and obviously all these people died. And so the property ultimately sold for $750,000, so way down from 2.2 million because nobody else wanted to touch it. So still, obligation to disclose the death on the property within 3 years, and the answer is yes. So notice that it says of an occupant of the property upon the property. So anywhere on the property, it doesn't care. Not all 40 of them were stuffed in bedroom number 2, right? They were all over the place. They were out in the yard. They were all in the corner. They were everywhere. So people, died on the property. All right. So the buyer comes in, does a movie, and then levels the house and builds a new house on the land. And so is there still an obligation to disclose the death of of an occupant of the property upon the property? And the answer is yes, if it occurred within the 3 years. Now I'm going to tell you that the law, and you must disclose the manner of death if asked, unless the death was a death by AIDS or HIV related illness. Okay, and so then you say, I don't have to tell you, and then everybody knows that's what it was. So okay, anyway, the bottom line is, I think this property is stigmatized, in that I think that obligation of a disclosure will carry on through time. And the reason is because it's a heinous act. It's a very serious thing. The Sharon Tate murders, people completely butchered in a house. Charles Manson wasn't even there, right? His people did it. And so I think some of them I know he passed away recently. I think some of the rest of them have passed as well. But obligation to disclose the death. So imagine this scenario where you open up the Union Tribune, the front page of the Union Tribune, 10 years after Heaven's Gate occurs, and the helicopters have taken a picture of the house, and you recognize it as the house that you just bought, that nobody told you about the 40 deaths on the property. So that's what I think. We want to be sensitive to the fact that of course, that disclosure, the person that sold them the house may not have been aware of the death, and so they wouldn't have had to make that disclosure. But you can still see that would be something that would probably be material, a material fact to the buyer. Okay, and then the rest of them, the MCM contamination, so methamphetamine contamination. Why do we have to disclose that? Because it still goes boom. And it's for a long, long time. It has to be professionally cleaned. Release of an illegal controlled substance on or beneath the property, whether it's located next to an industrial zone, whether it's affected by a nuisance created by an industrial zone. These are all statutory or contractually related requirements. Within a mile of a former federal or state ordinance location like Coronado, the Strand. The Navy used to sit out in the water and launch 16-inch guns at this thing. And so shells, not gun, the guns stay on the ship, but launch these things at the Strand because they like to see the sand go puff. Well, sometimes these things didn't explode. And so we had the same problem in Tierra Santa. And this is going to take us into the SPQA, which is the local disclosure. So again, this form came out of San Diego, and I think it was well done by the California Association of Realtors. But these are all my disclosures in paragraph 6 that are still required by law. Insurance claims affecting the property within the last 5 years, yes or no? And if the answer is yes, just describe it. Tell us what that was all about, right? So that and then the rest of it is kind of follows along the same line. Are you seller aware of? Yes, no, and we won't go through each line by line. But in looking at the form, I can look at it and I can tell you what's missing. Right. And so what does that take us? That takes us into the next form, which is, again, the SPQA, and that is the Seller Property Questionnaire Addendum. That is the standard of care in San Diego County. Okay, very, very important concept. Remember, standard of care. That's what I testify on. So I'm going to take a look at my SPQA, and this is the form that San Diego created when California created the statewide form. We came along and we said, yeah, but there's a whole bunch of stuff that's unique to San Diego County, and so this would be used in the San Diego area. But San Diego says we don't need to talk about everything that's in the SPQ because some of these things you did a good job and you covered them. So like SPQ question number 5, and so let's go to number 5. I just want to give you this as an example. We're not going to do this all day, but number 5, documents, and this is where the SPQ talks talks about documents. And then number 5, San Diego says, oh, you pretty much, nailed that. A couple little things in here we're going to add to it. 6, nothing to talk about. 7, attach copies of documents if applicable, because 7 is not, it doesn't say that in the statewide form. That's all. So essentially think of it this way. I've got the TDS. Next to it, I've got the SPQ. Next to that, I have the SPQA. So one flows to the other, and that's how I want to think about these forms. I frequently have agents say to me, I gave you the SPQ, I'm not going to give you an SPQA. I have a transaction right now where they're refusing to give us an SPQA. So I've got like 3, please give us this form. I'm getting back our brokerage doesn't require it. Listen, I know your broker. I think your broker does require it. So you probably have never met your broker. I'm in meetings with your broker all the time. and we talk about things at a certain level. And we are eye to eye on most of these things. So again, statutory or contractually related required. Number 6, we think you killed that. You did a great job, right? That's the ESD. Okay, so that's what the SPQA does. It just breaks down the things that the SPQ missed. And remember, the SPQ cover the things that the TDS missed. And so we're still going to have, how many pages do we get? We got a lot of things we don't have to talk about, but we're going to get down to, I think San Diego did a great job of creating the buyer's legal duty to exercise reasonable care. And again, this was put together by the attorneys on the committee. And that's another 6 pages. So it's a lot of pages. It's a lot of filling out by the seller, but I think you would agree with me that after you've completed, a 3-page TDS and a 6-page SPQ and a 6-page SPQA, I think you probably covered most everything, right? So woe it be to the real estate agent that sends these forms to the seller and says, fill them out, call me if you have any questions. That is a very weak defense, okay? In fact, I won't take that case. And I've had cases against agents where that's what they said. I gave it to the TC, the TC forwarded it to the buyer, and there we go. It's not a question of just getting something signed. You have an obligation at law to advise and counsel your client. Okay, and to ask questions about things. So the SPQA is the standard of care in San Diego County, all right? And so again, remember, on Friday, I did the legal documentation necessary in a real estate transaction for the Department of Real Estate. I might kind of know what I'm talking about. Lead-based paint and lead-based paint hazards disclosure acknowledgement and addendum, and that's going to be for pre-1978 housing sales, leases, and rentals, okay? It's an EPA regulation. It's 42 U.S. Code 485-52D. Let's go ahead and talk about that really quick. Hopefully I'm going to get you out of here early. Let's go ahead and kill the SPQ. So here's my lead-based paint. So we've renamed it. It was the FLD, the Federal Lead Disclosure. Now it's the LPD, the Lead Paint Disclosure. It's really not a law. Well, actually it is, because it's civil code, or it's a U.S. code, but it's really an EPA regulation. And so I often talk about this. I could spend an hour on this form, but you only need to watch one video on YouTube of what happens to a child who has been eating the lead paint and the permanent brain damage that it does. Irreversible brain damage. It's a horrible thing to see. Don't go looking for it. I mean, it really is bad. But this is why the law is in place, is to try to protect the people that just can't automatically be protected. Now again, it has to do with properties built pre-78. So a lot of properties in San Diego don't qualify for that, right? But let's not get into an argument about, remember that the paint is around. It's just against the law to put it into a residential property. It happens, so you got to watch out. But here's how it works. So anyway, make sure you're using the current form, again 1221, and there were some changes to it. So for example, my the lead-based paint renovation rule. So first of all, the warning. The second thing is the warning for leases and rentals. And then the third thing is the renovation rules. So this applies to anytime you displace lead-based paints, 6 square feet of lead-based paint in a room, or more than 20 square feet of lead-based paint on the exterior, you must have this done by a licensed certified professional. Okay. And so I've had this done. It's not much more expensive than you would have paid somebody else to do it, but you want that OSHA certification. You want the proof that it was disposed of properly. I frequently see the form not completed. If there's nothing in one, then tell me nothing, or no, or NA. If there's nothing in the second part, I have no reports, but don't leave a blank line. So lawyers don't like blank spaces, right? Because they lend themselves to people filling things above them for one thing. I just can't leave a blank. So I'm going to, the seller's going to put in no or NA, unless they know of something. And if they know of something, then they need to say yes. Okay. All right. Buyer's got 10 days, which unfortunately they can waive in the purchase agreement to conduct their risk assessment of the property. Okay. And then the seller signs it. And then over here, the buyer or tenant initials it. Good catch by CAR with the tenant. And then on page 2, they haven't made this change yet. This should say the seller's agent, right? Has informed, under the 42 U.S. code again, and is aware of the agent's responsibility to ensure compliance. And then they sign it. Seller or housing provider. Housing provider would be the management company or the owner of the property, and then buyers or tenants acknowledgement. And again, and remember, and this is an interesting little catch, because you are required by law to include the environmental hazards booklet in your sales, but also in your rentals. So when you're doing a sales transaction, we frequently use like property ID or something, and they will provide the environmental hazards booklet for you. But when you get into a rental property where that is still required, doesn't matter when it was built, that's still required, you need to pull that up out of your zip forms product and make sure that the buyer has signed, or the tenant in that case has signed off on all of that. And so those documents are in the forms under EPUBs, and there are 6 of them. It includes the earthquake hazard, which obviously is not necessary unless the property is built prior to 1960, lead-based paint prior to 1978, defensible space prior to 2010, those kinds of things. Okay, so again, here the buyer could actually waive the right to conduct an assessment. I would recommend against that, but all right. And then the cooperating broker, I don't know, we don't just call that the buyer's agent. See, up here we had the buyer, up here we had the listing agent, should have been the seller's agent. This is just a form we haven't gotten around to correcting, and I frequently send notations off to CAR, and next thing you know, we do something called a soft publish, and that means we fix it, but we really didn't wait until the first of the year to do it, because we figured it was one of those little things that isn't going to matter a whole bunch, but at some point we're going to fix it. And so that's why I tell you to always use a template, because if you've created a template in the program, then the template will get updated automatically, even with the soft publish. And that means that as you create a new transaction, or as you apply a template to a transaction, you will have the most current version of the forms. Everybody good with that? Anybody have any questions on any of that? I'm going to take us back to my PowerPoint. And there you go. So that's my lead-based paint. Honorable mention, I just want to throw a couple things in there. So my PRBS form, interesting form. The genesis of the form was, let me see if I can pull that up really fast here. So the genesis of the form was that, we like to do dual agency in California, because we get paid twice as much, but we also have to have permission to do that. This is the form that gives you that permission. Multiple buyers, multiple sellers in an area. And so it actually came out of a lawsuit in North County in San Diego, where the seller listed their property with a broker, and they listed it for, I think it was $720,000. Then another seller across the street listed their property with the same broker for $480,000. And by the way, there were 2 completely different parts of town, but they were all under the same broker. So the seller sues and says, the first seller sues and says, you just caused my property to go down in value, because frankly, I wanted 720. You just listed competition across the street for 480. And so, you just caused my property to go down in value. And you know what? They won. And the court held that, yeah, you need to have permission to represent competing sellers in the area from all of the sellers, if you're under the same brokerage firm. And so they won. done. And so that's where the form came from. And this is why we disclose and we get consent to dual agency before we even take them out in the car, before we even list the property. Okay. Another offshoot is that we tell everybody that their offers are not necessarily confidential, and that was a change to the code of ethics, January of 2008. We changed the code of ethics to authorize the seller's agent, with permission of the seller, which is in our listing agreements now, to disclose the content and terms of competing offers to competing buyers. Surprised a lot of people have been around a long time, because they still thought that all that was sacrosanct, and that they couldn't disclose those things. But the fact of the matter is, yeah, you can tell competing buyers of the content and terms of competing offers. The DRE had a problem with that, but a couple months later they realized, oh, okay, that makes sense. Your goal is to get as much as you can for the seller, and so you got permission by both sides to do that. So that's what we're going to do. Okay, all right. That being said, that was my PRBS form, CAR form PRBS, and then our local area disclosures. Again, the last of our honorable mentions here. The local area disclosures come out of San Diego, and they're awesome. And I'll frequently go to do talks around the country, and I'll get, I'll walk into a meeting and here's the SDR's local area disclosures up on the board, and he uses an example of what local associations should be doing for their members. So one of our flagship forms, and it was revised just here now in January of 2023. So great form, breaks it down. This was the original grid that you now see in the CAR forms. The SBSA is the original grid, but this is a great little form, breaks it down by areas, and I assure you, some very bright people put this together. Some very bright attorneys on the San Diego's Risk Management Committee. So there's a signature page down here. We used to have it as a separate page, but then we realized we really needed to have, we don't make you initial every page. So what we needed to make sure that the buyer had actually received the report. Okay. All right. So that being said, we're going to go back to our form. And so CAR and NAR use this as an example of what local associations should do for their membership. And so I want to thank you for being here today. It looks like I might get you out of here a couple minutes early. So for our conversation about the top 6 disclosures, if you want to view any of our previous webinars, please visit our new YouTube website. So get your QR code reader ready. There it is. Line it up, take a picture. I load all of these webinars up onto the YouTube website for you to be able to see at any time. And so you can also go to @Burke Real Estate Consultants Inc. Or you could go to bit.ly bit.ly/real-estate-ed. The DRE has required me, because they've approved my RPA class for 5 hours of continuing ed, and my buyer representation class for 3 hours of continuing ed, but I have to put up on our website, when I start doing the classes, the general information page. And that's why we're doing this, is so that you'll have the general information page available to you, so that you know what you're signing up for. And I did both of those presentations for NAREB and CAREB in Oakland a couple weeks ago, and I got to tell you, a packed house. The morning meeting of the first part of the RPA, probably half the room, and then by the time, when the second part started later, they'd all gone out, told all their friends, and they pretty much packed the room. It was great. So I want people to know this stuff. The DRE portion of it has to be live and in person. So reach out to SDAR, say, when is Kevin going to do the 5 hours of continuing ed RPA? I received a great compliment from the Department of Real Estate. They called me on the phone and they said, we're looking to see, they require, so for every hour I have to do 3 pages of written content. I'm sitting here thinking, how am I going to do that? I ended up with 36 pages. And so they called me on the phone and they said, we are so looking forward to reading your thoughts on the RPA. And so that'll be something I'll include for for everybody in the class, but it was really quite an honor to get that from them. It's kind of one of many career highs I've had with the Department of Real Estate. So case is important here. Please remember when you go there, like and subscribe. So like, just because it makes me feel good. I don't get donuts or anything for that. Subscribe so that you get updated every time I load an update to the site. Okay. And this is going to be important for you to get the newsletter, because the podcasts are coming. I'm going to be doing podcasts. I have the prosecutor for the city of Huntington Beach. They want to talk about a real estate deal that went very bad. I have a lot of attorneys that are going to be talking. And so I'm going to end up being the moderator. Obviously, I know which questions to ask. And then I'm going to be doing, so I say stay tuned for the podcast. 29th of November, the DRE will publish the podcast I did last week. So here's the website for it. It's dre.ca.gov, consumers, first home California. So here it is. And I'm honored to be on it. But this is their website. So again, consumers/first home California.html. You can also just click on consumers and then hover down to First Home California right here, and it'll take you right to this page. Okay, so lots of good stuff coming from the Department of Real Estate, and I'm kind of proud to be part of that change. So I was the guest speaker on legal documentation in a real estate transaction. It was just myself and the assistant commissioner for marketing, who just a super guy, and he just asked such great questions, and again, I'm nothing without the questions, so but I'm rambling on, and it was a lot of fun. I really did enjoy it. So the majority of complaints, interestingly enough, I found this out, the majority of complaints filed with Cal DRE are from first-time home buyers, and I think that's really sad. Remember when I talked earlier about entry-level housing and 2003 and how the market, had come to a complete stop at the low end. And so we need to take care of our entry-level housing. We need to take care of our first-time home buyers. I will take a first-time home buyer all day long. I'd rather work with them. They're appreciative of what you do. They tend to be very thoughtful. They tend to be great referral sources. Take good care of them. Let's get the complaints down. I think it's just sad, because this kind of tells me that either the real estate agent didn't give them the focus that they needed, or maybe didn't know how to do it, and maybe just kind of shined them on or went quiet on them during the transaction. And I'm just hoping that never happens to you. I just think it's a sad statement. Okay, so probably my first podcast will probably be getting into the buyer representation broker compensation agreement as a result of the Burnett case. Now all of a sudden everybody wants to do it. I've been teaching it for 25 years, and like I said, I'm approved for DRE credit, but I did this long before the Burnett case. If you have any other things that you want us to talk about, please let SDAR know. You can send an email to education@sdar.com, or you can and copy me, or you can send it to me and copy them, whatever. But let's talk about the things that you'd like to see us do. Okay, so or see them do. I do have weekly email updates. They go out on every Friday, so I'll have another one going out for tomorrow, Friday night. But I don't put people on it unless you ask to be put on it. But again, it's going to give you notice of when the podcasts are occurring. So currently all my stuff on the YouTube website is free. I can't promise you how long that will be. I'll probably grandfather people in on it. There'll probably be a modest fee in the future for the podcasts, only because I have to, foot the bill for it. But I'm anticipating quite a return on the time that we spend with it, because again, we're here to help people, and we're not in it for the money. We just want to cover our costs. So anyway, I want to thank you all. Does anybody have any questions about anything that we've talked about so far today? I know we've covered a lot of material. Not seeing any questions. I want to thank you for being here, and I wish you the very best of the weekend. As we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Take care for now. Have a great day. Bye-bye now.